On Friday, July 12th, the Alec Baldwin trial continued with day 3, and in a shocking and surprising twist, it also concluded on day 3. I don't think anyone expected any of this to happen, especially in such a dramatic way. Going into day 3, we thought that there was going to be a hearing lasting about 45 minutes to maybe an hour, and that this would likely be over some sort of evidentiary issues. Then we expected to continue with the prosecution's case in chief. However, this very quickly got completely off the rails as the defense brought up an incredibly important issue that I actually touched on in the day 2 recap, and that is Brady violations. Let me just tell you, I have never seen anything like this before. And so this video has taken me a little bit to complete because I wanted to make sure to get all of the important details right, so I appreciate your patience on this one. Let's get into it. So going into the hearing, we thought that this was going to be some kind of argument over evidence that maybe the defense wanted in their case, or that they wanted to be excluded from the prosecution side. But to start off, defense attorney Alex Spiro actually got up first and told the judge about what he says was a concerning photo of Special Prosecutor Kari Morrissey that he said that he had received from someone by an email. Specifically, what he said about it was that it looked like Morrissey was signaling the witnesses on the stand.
And I get many sort of inbound emails that I don't obviously read everyone or take everyone seriously, but I got one last night that indicated that the cameras are catching Miss Morrissey signaling witnesses while they're on the witness stand. And I really...
Did you look to see if that was true?
I was sent a photograph that concerned me. And I felt obligated, and like I said to the court, I try to not make these issues, this is a high-pressure case. I've been in many. There have been more issues in this case than I have ever seen in all of those cases combined. And so I'm sort of at a loss, but to bring it to the court's attention. So I've asked them to print me the photograph that was sent to me. I can't just continue to give the benefit of the doubt on every single thing that's occurred in this case. I just can't.
Now, when I was live streaming this in real time, I will admit I thought Spiro had said Morrissey was signaling to the jury. And the reason for that was because on Twitter, someone had tagged me in a screenshot from the day 2 live stream that seemed to suggest that that's what she was doing. Now, I will say it wasn't actually clear to me whether she really was making an improper gesture in the courtroom here. I know that many times in many of the cases that we've watched and commented on, people have taken screenshots of the attorneys or even sometimes the judges where they're resting their faces on their hands, for example, or maybe holding things in their hands, and maybe they have a middle finger up, but when you really look at it, and particularly in context, it doesn't really mean the gesture that they might otherwise look like. And when you do take just a screenshot in the midst of the greater context of the live feed, you do often realize, maybe this isn't what it appears like at first. But in listening back, with Spiro actually saying that he thought that she was signaling to the witnesses, not to the jury, I thought maybe this photo wasn't what he was talking about then. But either way, if what he was saying was correct, this would indicate some troubling behavior by Morrissey if she's trying to coach the witnesses on the stand. Anyway, this sounded like we would be seeing more on this by the end of the day, but we never actually ended up seeing that photo. And to be honest, I don't even know if Judge Mary Marlowe Summer ended up seeing it because the rest of the day ended up being taken up by what actually turned out to be the defense's motion to dismiss the entire case. So with that, let's get to the real focus of the day, the motion to dismiss. This motion really came out of CST Marissa Popple's testimony on day 2. If you remember, on cross-examination, one of the things that did come out was that there was a quote-unquote good Samaritan that apparently brought a set of live rounds to the Santa Fe County Sheriff's Department. And one thing that came out of her testimony was that Ms. Popple did the intake of these rounds when the Good Samaritan came in and even got a statement from him. Despite that, Ms. Popple admitted that she did not send these live rounds to the FBI for any kind of testing. She didn't really formally document the intake of the rounds, at least not in the Rust case anyway, and she didn't inform the defense about it. Now, I noted a couple things about all of this in the day 2 recap. Number 1, I did criticize defense attorney Alex Spiro for how much time he was burning with this witness on cross-examination. It felt like he was taking a really long time to get through everything, where he could have been more organized and more precise. I also said that this appeared to be a fairly big mistake for the defense because of the fact that Special Prosecutor Kari Morrissey then came up on redirect and added all kinds of contextual information that seemed to change the character of the testimony about the Good Samaritan. And so this made it look like the defense was maybe trying to pull a fast one on the jury by only telling part of the story about this Good Samaritan and the live rounds that he brought to Miss Popple. But finally, I also said that there was something about this that seemed to suggest a possible Brady violation by the prosecution. But I wasn't sure if that was something that had already been addressed in some pretrial hearing or what. Now, based on what we learned from day 3 that we didn't know on day 2, I do need to revisit some of my commentary on the cross-examination. For one thing, there was my opinion that Spyro was struggling with this cross-examination by doing things like burning more time than he should have, and that the defense looked like they were trying to pull this fast one over the jury by not giving important contextual information to the jury about this whole issue about Troy Teske and the live rounds. However, after day 3, it had me wondering if Spyro was, maybe in going through this cross-examination, working with newly acquired information that would suggest the possibility of a Brady violation. And I'm wondering if he was trying to figure out how to get more information on the fly that could help the defense draw out more about a potential violation there. This could explain why he was taking up so much time on this cross-examination and why things weren't as smooth as they could have been. Anyway, then there's the part where I criticized the defense for only giving part of the story about the quote-unquote Good Samaritan, saying that it looked like they were being sneaky about the important contextual facts about this Good Samaritan. But now, based on what came out on day 3, I'm not so sure if the defense even knew that information themselves until the prosecution got up to do their redirect. And if that's the case, the defense wasn't being sneaky. They were being prejudiced in that moment by a real-time Brady violation by the prosecution. And that is a huge, huge difference. Okay, but I admit that I am getting ahead of myself here just a little bit. Let me take a step back and give a brief overview of what the main argument was in this motion to dismiss, and then we'll talk about Brady violations and what the standard even is so that we can talk about what the judge decided here on day 3 and why. So first is the motion itself. It was chiefly argued by defense attorney Luke Nickus, who we haven't heard all that much from so far in this case, at least not when it comes to cross-examining witnesses. He made the arguments for the motion on behalf of the defense, and I have to say his arguments were very organized, crisp, and clear. In a nutshell, he said that the case needed to be dismissed because the prosecution violated defendant Alec Baldwin's constitutional rights. And specifically, these were because of conduct by the prosecution that amount to Brady violations related to evidence of the origin of the live rounds that made it onto the set of the Rust film, one of which, of course, killed Halyna Hutchins. Here's where the rounds are potentially significant to this trial and the trial of Hannah Gutierrez-Reed for that matter. Both of these defendants have argued that someone brought live rounds on set, that it was some kind of sabotage, and that it definitely wasn't them. For this, both have pointed to actually Seth Kenney, the owner of PDQ Props, the prop company that supplied the Rust film set with all of its props. But at the same time, there's also been this whole question about whether they can track the live rounds from the Rust set to anyone specifically. Well, in comes Troy Teske, the quote-unquote Good Samaritan, who first came up on day 2 of this trial. As it turns out, he outlined a chain of custody through Seth Kenney particularly from the 1883 TV series and a cowboy training camp that Seth Kenney and Fel Reed had worked on. And Troy Teske then linked that to the Rust set. In other words, Troy Teske said, "These rounds that I have right here with me are a part of the same group of rounds that Seth Kenney and Fel Reed took from to use at the cowboy training camp for the 1883 show." At the end, Seth Kenney ended up with the remainder of all of those rounds. And Teske said, "Those are the rounds that ended up on the set of Rust." And so he said, "I want to turn these over to the investigators so that you can test them and see that these rounds that I've been holding on to that are part of that original group that all of these rounds came from are actually a match to the Rust set's live rounds." Now, if they are a match, that is good evidence that Seth Kenney was the guy who brought the live rounds on set. So in this motion argument, Nickus not only outlined this explanation, but he also gave a timeline of events showing when the prosecution knew about this information and what they did and didn't do with it. Nick has pointed out that the prosecution knew about these rounds as early as November 1st, 2021, when Seth Kenney came in to talk to then Detective Hancock, now Corporal Hancock. When Seth Kenney was there with Hancock, he called up Troy Teske, who originally told Hancock all about these rounds. Kenney said that these could be a match to the rounds on the set of Rust that killed Halyna Hutchins. Teske also apparently sent a photo of the 4 rounds, not all of them, but just 4 of them. And this photo becomes important to the prosecution because it's basically all they looked at to determine whether or not these had any evidentiary value. Anyway, then on November 2nd, 2023, there was a pretrial conference between Kari Morrissey, Hancock, and Troy Teske. And in that pretrial conference, Teske told Morrissey all about these rounds. And so Morrissey told him, hang on to them, we'll come to you and pick them up in Arizona. But she never did. Now, in Morrissey's counterargument, she said that the reason why she didn't try to get these from Teske and the reason why she didn't ask for the rounds to be tested when they in fact did receive them much later, and the reason why she didn't disclose any of this to the Baldwin defense was because she said that she looked at that photo that Teske had sent on November 1st, 2021 and determined that they are not a match to the live rounds that were found on the Rust set. Namely, they needed to be starline brass with a nickel primer and not showing other signs of a dummy or blank. Here, she had said, these rounds brought in by Teske didn't have a nickel primer, they had a brass primer. And so this is actually taking things out of order a bit in terms of how things played out at the hearing, but I might as well show this here. Morrissey also took the stand as a witness at the end of this hearing, even though Judge Marlowe Sommers told her that she didn't need to do it. Neither she nor the defense was asking her to testify. Morrissey was still like, nope, this is the best idea ever. I can't wait to do this. I'm going to go ahead and do it. Personally, I think she was wrong, but hey, she knew what she was doing, seemingly. Anyway, here's her testimony talking about how the main reason that she did what she did was because she didn't think these rounds brought in by Teske had any evidentiary value.
I did at this point have some understanding that Mr. Teske had had contact with law enforcement regarding these rounds that he still had in Arizona. So these are rounds that never left Arizona. They were always in the possession of Thel Reed and Troy Teske. They never went to Texas. They never came to New Mexico. That's what all of the evidence indicated. So I understood that Detective Hancock had communication with Mr. Teske about trying to get those rounds, and Detective Hancock was unable to get those rounds from Mr. Teske. I did not find that particularly concerning because those rounds had never left Arizona. The filming of Rust was in the state of New Mexico. And the rounds that were taken from PDQ went from Arizona to Texas to Albuquerque. So ammunition that is in the state of Arizona that has never left Arizona did not strike me that it had significant evidentiary value. Then, and I will say, I believe I actually saw a photo of it. At that point in time, I was able to look at the ammunition myself, and it was visibly dissimilar than the rounds from the set of Rust.
Now, first of all, of course, there is a question as to how solid she can really be on a question like that from just a photo. After all, the prosecution team had sent off all the other live rounds to be tested by the FBI on a much more detailed level. So how could she say that with just a cursory view through a photo, which could have discolorations due to lighting and whatnot, when coloring of that primer was so important? This is not even after a personal examination of the rounds themselves. So how could she be certain that these aren't a match? So that's issue number one. Then there's what she did when the rounds were actually brought to the Santa Fe Sheriff's Department, because a few other important details came out that raised some serious eyebrows here. Number one, when Troy Teske brought the live rounds to the Santa Fe County Sheriff's Department, he met with CST Marissa Popple. Specifically, it was her and a police officer, Lieutenant Brian Brandel, who met with Troy Teske and then drew up a supplemental report on the meeting. In that report, Lieutenant Brandel apparently wrote that the live rounds were not evidence in the case. And that's definitely a red flag because you can say if it's relevant or irrelevant, admissible or inadmissible, but this is definitely evidence in this case. But apparently there was a whole discussion that had happened between CST Popple, Corporal Hancock, and Kari Morrissey about what to do with this evidence that was brought in on March 6, 2024. Morrissey said that this wasn't really evidence because she determined that it wasn't relevant to this case because the live rounds weren't a match to the live rounds on the set of Rust. And so they all agreed that the right course of action was not to put these rounds in with all of the other evidence for the file under the Rust case's case number. Apparently. There is some disagreement on this, but this seems to be the best possible explanation for what happened. Because the most consistent, version of this timeline seems to be that instead they opened up a whole new case number that no one on the defense even knew about, and no one told the defense about, and put it in there.
Don't be suspicious. 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 Don't be suspicious.
John Ralphio?
Now keep in mind, this decision to put this evidence under a completely different case name was after they had the opportunity to personally inspect the live rounds themselves. At least the opportunity to do so. This is also important because during the hearing, when Judge Mary Marlowe Sommers ordered the appearance of CST Popple and Corporal Hancock, she also led her own investigation with both legal teams to examine the live rounds in person. Now, I have to say, I've never seen anything like this. The judge putting on latex gloves and getting down from the bench to look at the evidence up close herself. This was an awesome thing to see because it showed that Judge Marlowe Sommers had a very keen interest in getting down to the actual bottom of this. As she examined them, she asked CST Popple, who was at the moment testifying technically on the stand, if any of these live rounds in question matched any of the live rounds found on the set of Rust. And sure enough, here's what Popple said.
Ziegler tested the rounds in the Hannah Gutierrez case, correct?
Yes.
He didn't test any further rounds after the Hannah Gutierrez case?
No.
Okay. In the Hannah Gutierrez case, can you point out what types he did test from here?
I'm uncertain what types he tested.
This is a witness testifying, Ms. Morrissey. Please stop.
We sent all of the...
All right, let me ask it a different way. Do you recognize any of these types of bullets to have been gathered on the Hannah Gutierrez, on the Rust set?
The Starline brass with silver primer are similar to what was collected on set.
And everything that was collected on set went to Ziegler?
Yes.
All right, thank you.
But then how can that be? When Morrissey said that the whole reason that she did what she did was because they weren't a match to the live rounds picked up from the Rust set. Given Popple's testimony, this means one of two things. Either Morrissey lied to the court about those rounds not being a match and tried to deceive the court by pointing only to the photo of the 4 rounds, knowing that there were rounds that Teske brought in that did match this Rust set rounds, or she didn't bother to ask CST Popple or Corporal Hancock the same question when the live rounds were brought in on March 6, 2024. According to CST Popple's testimony not long later, it does appear to be the latter, if that is all to be believed. There's definitely some skepticism, some room for skepticism in a lot of this.
Ms. Popple, I just presented to the court that I've never seen these until this morning. Do you agree with that?
Yes.
You've never shown me these, or I've never come in to see them, is that right?
Correct.
Have you ever provided me that doc report?
No, I have not.
Okay.
But either way, this is not good. And that's for a number of reasons. First, there's the fact that there is in fact a match to the live rounds on the Rust set. And this was confirmed again by CST Popple when she testified further at this hearing, and she admitted that she could tell this right away when they were brought in by Troy Teske on March 6, 2024.
So he turns this round in, and you, when he turns it in, obviously recognize it as Starline brass, nickel primer, Colt 45, correct?
Yes.
Okay. So it's not as if he came in and just turned in a bunch of shells, right?
He did turn in a whole bunch of shells.
Okay, but he didn't just turn in shells, right?
He turned in multiple different .45 rounds.
I'll ask the question a third time. He didn't just turn in shells, did he?
He turned in multiple .45 rounds.
Including rounds that matched the round that struck Miss Hutchins, right?
Again, I wouldn't use the word match without further analysis.
And the reason that we don't have further analysis is you all didn't send this to the FBI for further analysis, did you?
We did not.
And although he didn't even really need to do this for the strength of the defense's position at this particular hearing, Alex Spiro also elicited from Corporal Hancock that on day 2, CST Popple actually gave completely false testimony about whether there were matching live rounds in the set that Troy Teske brought in.
Are you aware, as you sit here, that there was 45 long Colt Starline brass nickel in the courtroom today from CST Popple?
I just found that out today.
Okay. So, you were here for this testimony in this courtroom. And let me ask you, Ms. Popple, the ammunition that the Good Samaritan Mr. Teske, the close friend of Hannah Gutierrez's dad, when that ammunition that he brought into you after the conviction, you still have it? Answer, yes. Question, you can bring it in here and you can show it to the jury, right? Answer, yes. And they can see for themselves that it does not match the live ammunition from the set of Rust, correct? Yes. And that it is obvious. Just when you look at it, it is not. Yes. Do you remember that testimony that you were sitting here for?
Yes, I do.
And that turns out to be completely false, doesn't it?
You're correct.
Anyway, another reason that this is a problem is because CST Popple testified that when these rounds were brought in, they were put under the entirely new separate case number that didn't have anything else in it related to Rust, and that they just didn't tell anyone on the defense about.
And you would agree with me, right, that it's the same as the bottom of the bullets that you just provided to the court?
Yes, it's Starline brass .45 Colt with a silver primer.
So when I asked you yesterday, didn't he turn in ammunition that matched the ammunition that killed Miss Hutchins? It's true that he did, correct?
And I did not recall at that time.
I understand that that's your position, but that's what in fact happened. Would you agree?
I would not use the word match without there being an additional analysis.
Well, who got to decide whether there would be additional analysis?
That was not myself.
It wasn't the defense, though, right? We didn't know about it.
I don't know what you were aware of.
Okay. Well, you know that we came to have an evidence viewing where we asked to see every single round that could be related to the Rust set, and this was hidden from us. You do know that.
This was not hidden.
This was not hidden?
This was under a case number. It was documented. I was instructed to document it under this case number.
Okay, so in this case that's under the Rust investigation case number, you would agree with me there's hundreds of things that you inventoried, right?
Yes.
There are hundreds of police reports that all relate to the same case number, right?
Yes.
The one thing that seems to have been put under a different case number is just this one discovery of the actual ammunition that matches the ammunition from the set of Rust.
This was put under a doc information of someone coming in claiming to have rounds that were not utilized in a case.
Okay, well, let's examine that for a second. When Seth Kenny comes into the precinct and he gives you ammunition, you vouchered it, right?
I was instructed to collect the ammunition from Seth Kenny.
Well, let me take a step back for a second just to make something clear. Investigator Popple, you're following orders, right, when you're doing these things, correct?
Can you please stop referring to me as investigator because it's creating a misnomer?
Okay, well, how would you, I apologize.
I'm a crime scene technician. I'm not an investigator.
Okay, I'm only doing that because it's shorter than crime scene technician.
CST works.
Perfect, okay. CST Popple. When you took the, you're effectively following orders when you're deciding whether to voucher this or voucher the Seth Kenny evidence, right?
You keep using the word voucher, and I'm not sure what context you're using it.
Yeah, I apologize for that word choice also. When you inventory and make a report, I think your testimony is you're doing it at the direction of supervisors. Is that fair?
Most of the time, yes.
Okay. So when Seth Kenny walks into the precinct and gives you ammunition and says it's from the Rust case, you all inventoried it, right?
Yes.
You took photos of it, right?
Yes.
You put it under the Rust case number, right?
Yes.
You turned it over to the defense, right?
According to my knowledge, yes.
Okay. Somebody else comes in to the precinct, okay? A man named Troy Teske, right?
Yes.
Who was a former police officer, right?
I believe he stated that, yes.
Okay. And I assume you all have the diligence to be able to confirm that, right?
I do not know if it was confirmed or not.
Okay. And he comes in and he also tells you he has evidence, right?
He told us 3 years later, after a trial, that he had evidence that the defense wanted him to use that he no longer wanted to hold on to.
Okay, let's break that down for a second, right? Mr. Teske isn't involved in your meetings with the prosecutors and Corporal Hancock's meetings with the prosecutors up until the trial, was he?
Not that I know of.
Okay, so doesn't it make sense that he would have seen the trial on television, been completely outraged at what he was watching, not trusted law enforcement, and then walked it into the precinct? Doesn't that make sense?
I do not know what would make sense to Mr. Teske.
Okay, didn't he in fact tell you, I don't trust Miss Morrissey and the prosecutors?
He did not state that to me.
He didn't on your oath? You're sure about that?
I do not recall him stating that.
And as a side note, regarding these cross-examinations, I will say that I know I've been critical of Alex Spiro's cross-examinations in the first couple days of this trial. But on day 3, technically the one of CST Popple wasn't really cross-examination. But since he was directing CST Popple, who is a witness for the prosecution and therefore technically hostile to the defense, it more or less was a cross-examination by all appearances. And on day 3's cross-examinations, Spiro showed that when it really, really matters, he can do a damn good cross-examination. But anyway, this bit about putting it under a different case number was further confirmed by Corporal Hancock at the same hearing. She also tried to throw CST Popple under the bus on this one, even though Corporal Hancock was the lead investigator in this case.
You took the item, but you took it and put it in a different box than the rest of the items in the Rust case, correct?
Well, I don't think they're all, I mean, I'm not the evidence technician, so I don't know how.
Well, you know this wasn't placed and designated as a Rust evidentiary matter. It was kept and vouchered, as you heard yesterday, under a completely separate identification number, correct?
A different case number.
Right?
Yes.
Unlike the hundreds and hundreds of other items that were collected in this case from a variety of sources, correct?
That's correct.
Okay, and a lot of those items were like random, irrelevant, tangential things that all went into CST Popple's inventory in this case, right?
I think all those items were collected on scenes through search warrants or through somebody that gave them to us that we could have had a conversation with. And I could be able to relate what that item was and how it may have been related to Rust.
There was no way to relate this item to Rust when the guy's in your precinct telling you this is related to Rust and you had spoken to him on speakerphone and you had gotten those text messages. There's no way to relate it?
Again, I didn't get a statement from him when he's dropping off this ammunition and didn't see it because I wasn't there when he was dropping the ammunition off.
Well, your colleagues got a statement, didn't they?
Yes.
So yeah, this definitely doesn't help the overall image of any of these people as they are throwing each other under the bus, getting caught in lies here and there, etc., etc. And along that same theme, Corporal Hancock told Judge Marlowe Sommers that the whole second case number thing was something that was decided after a conversation with basically everyone about what to do with this evidence. And this included Kari Morrissey.
So, did you and Popple have a conversation about what to do with this ammo?
To my understanding, it was that it was going to be put in evidence.
Which evidence?
At the sheriff's office.
The Rust evidence?
No.
Why not?
Just as far in our evidence section in the sheriff's office.
And why was that determination made?
As to why
Who
it
made
was.
it? Let me ask you, who made it?
These were discussions that were had with myself, with the supervisors at that time, and then with the prosecutors.
Were you the lead investigator?
Yes.
Okay. And you said, and with the prosecutors?
Yes, ma'am.
Okay, so you all had discussions about what to do with what he dropped off?
Yes.
And you all agreed to put it in this separate file?
Yes.
Now, let's talk about Kari Morrissey, the lead special prosecutor in this case, for a moment. I already mentioned earlier that she chose to throw herself up on the witness stand to testify about why she withheld this evidence, for better or for worse. And for one thing, like I said, this is wild. I would never recommend any attorney do this, no matter how confident he or she feels about their position, because you can be dead wrong and sometimes not even realize it because you've fooled yourself into thinking you are absolutely right. Especially if you happen to have a personality type that seems to think that you're always the smartest one in the room, which Morrissey kind of does have. And then when you do put yourself on the stand, you might end up admitting to all kinds of crazy things all over the place. For example, here she is confidently admitting to withholding a number of pieces of evidence from the Baldwin team.
You served a certificate of compliance with 5501, correct?
I did.
And you've never turned over the report or any of the evidence that we're talking about here at this hearing, correct?
Let's take it one at a time. I did not turn over the report. I didn't have a copy of the report. The rounds that were left at the Sheriff's Department by Troy Teske, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Val Reed and never left the state of Arizona.
You also did not allow the defense to view that evidence at any point during our request to review evidence in this case?
I had never seen it, and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer and I don't work at the Sheriff's Department. But you are right.
Now, one thing that is weird is that she just said in that last clip that she didn't know it was under a separate case number. But remember, Corporal Hancock testified that Morrissey was part of the conversation about putting the evidence under a different case number. So obviously, one of them is definitely lying here. Now, for purposes of a Brady violation analysis, this really doesn't matter, and I'll explain that in just a minute, but like, holy hell, this whole hearing feels like everyone from the Santa Fe County Sheriff's Department and the prosecution team here is just lying, throwing each other under the bus, and otherwise just coming across as incredibly scummy. It definitely has the feeling of like rats just scurrying from a sinking ship, and it's not a good look for any of them. But anyway, Morrissey's testimony continued when she acknowledged that the Teske live rounds do match the rounds found on the set of Rust, but she maintained her position that they're somehow not relevant to the case. And she acknowledged other pieces of evidence that she withheld, giving other excuses for why she said she did that.
And you concede that they are Starline brass silver 45, right?
I can. And this is the best evidence against Hannah Gutierrez.
Yeah, you've said that a couple of times. Any favorable evidence you understand as a prosecutor has to be turned over to the defense, correct?
I do.
Any evidence that could be used as a defense to potentially be favorable has to be turned over to the defense.
Absolutely.
So the third Hague report that never got turned over to the defense, you understand that that's Brady evidence?
I did, yes.
Okay. And you also failed to turn that over in this case as well, correct?
And let me give you a full answer to your question. When the second Hague report came in, and I provided all of this to the defense, I sent it to the person who is managing the discovery server and asked them to upload it. It wasn't until I realized during pretrial interviews that it wasn't there that there was a problem with it. So I then attempted to figure out what the problem was, and it was indicated to me that it appeared that the former paralegal who was working for the special prosecutor had removed it. So we then immediately provided it. Then during the pretrial interview of Mr. Hague, it was brought to my attention that the defense did not have the August 31st report that indicated that the gun functioned fine, perfectly fine, and that was provided immediately. I went back, I checked my email, I could see that I received it from Mr. Haig and failed to forward it on to be uploaded. And I provided it as soon as I was aware that you did not have it.
The fact that nobody at the Hannah Gutierrez-Reed trial cross-examined Mr. Haig about the report didn't clue you into the fact that nobody had the report?
Actually, it didn't, and I'd like to address that. The reason that it didn't clue me in is because Hannah Gutierrez's defense was that the gun worked perfectly. The defense in Hannah Gutierrez was never interested in any evidence that there was an issue with the gun, because if there was an issue with the gun, it damaged her case. So what you could see, if you watched the trial or saw any of the transcripts, the defense actually brought in their own expert to say that the gun worked perfectly. So they had no interest in that information.
And actually, you elicited testimony from Mr. Haig at that trial that was inconsistent, at least partially inconsistent, as the court's aware, with his third report, correct?
Tell me what you're referring to, and I'll answer your question.
Well, there was a whole hearing about this where you saw this, and you saw me go back and forth with Mr. Haig for 25 minutes. So I don't.
I agree, but I need to know what you're talking about for me to answer your question.
Okay, if you can't answer the question, you can't answer the question. I'll move on.
I'm happy to, but
You say that the extent of the communications you have about the doc report, as you relay it to the court, is that all you said in response was, "Great, do that." That's your testimony?
yeah, I assumed that it was going to be tied to the same case number. So I said, great, do it, file a report.
No follow-up questions?
No, because I had a picture of the ammunition that didn't match the ammunition from the set of Rust.
No concerns in your mind when you got the case file and you turned it over to us and it wasn't included?
Absolutely not. There's a terabyte of discovery. I didn't know whether this 2-page police report had been provided. And in addition to that, I had no reason to believe, and still have no reason to believe, that those rounds have anything to do with these cases.
As I asked you about Mr. Haig yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false.
What part of her testimony was false? And I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you, and I didn't realize that there were rounds that looked like that.
It's okay. In any event, when the court, and you never tested those rounds either, correct?
Any of the rounds that came from Mr. Teske? No, because they came in just a few months ago.
And the court asked you actually one question that I want to address, which is, the court said to you, well, what's interesting to me, to be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response. And what you said to the court was, I never saw these, I've never seen these, and I never saw the report. I have absolutely never seen these until this morning. Do you remember saying that to the court?
With regard to the 3 Starline brass, with regard to the 3 cartridges that appeared to be similar to Rust, yes.
Well,
I never saw them until today.
Well, but you said also, I never saw the report, right?
I never did.
Right, but don't you think, given your duty of candor to this court, that that's awfully misleading to not tell the court at that point that you knew about this when it occurred long ago?
That I knew about what?
You knew that Mr. Teske had turned in this evidence, that you knew that the report would have existed because you just told this court that the doc report was okayed by you.
Sure.
Don't you think it was misleading to this court to not just say at that point, you know, just so you know, I know about this, I knew about this then, I was involved?
I did not intend to mislead the court. My understanding of what was dropped off at the sheriff's department is on this computer screen, and it looks absolutely nothing like the live rounds from the set of Rust.
So as you can see, really Morrissey's argument here relies on her own analysis of what the defense's strategy is and whether or not this is good evidence for that strategy. And there's a problem with that. And that is, she really has no idea what the defense strategy is until they employ it at the trial. Of course, there are hints of what it likely will be at a high-profile trial when the parties are making arguments to the press. But she really cannot sit there as a special prosecutor and say, I know what's best for the defense, and I know that this piece of evidence is absolutely not significant for their case. Again, this has the feel of someone who is considering themselves to be the smartest person in the room. They might not be right. Other people might disagree with her, and therefore that might actually be very important evidence to their particular case and to their strategy, and she has no idea. She simply cannot presume that. But even aside from that, that's also just not a good argument under Brady v. Maryland and the analysis that has to be put over this kind of an issue. So let's talk about what the actual legal standard is here. So if you're not familiar with Brady v. Maryland or the term Brady violations, Brady v. Maryland is a Supreme Court case from 1963 that held that prosecutors need to provide exculpatory evidence to the defense. This means any evidence that is material either to guilt or to punishment. Now, since 1963, there have actually been a ton of Supreme Court cases that have continued to develop what this all means and what the outer limits are for this particular issue. For example, when we talk about materiality, this means evidence that could have affected the outcome of the trial. Or materiality could also be defined to include evidence that might undermine confidence in the verdict. This can mean evidence that is as middle of the target as proving the defendant's actual innocence. Or it can be as simple as information that could decrease the prosecution's witnesses' credibility. And very importantly, there's no excuse allowed for a prosecutor to say, I didn't know this detail because I'm not employed by law enforcement, as we heard from Miss Morrissey. That's because the prosecutor has an affirmative duty to search their files and the files of law enforcement officers who work on the case for material evidence. All of this stuff is actually super clear, and I'm really surprised that Kari Morrissey, who otherwise typically is actually a criminal defense attorney, doesn't seem to know or appreciate any of this. But anyway, to package all of this together, there are essentially three components to a Brady violation. First, the evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. As a side note, on its face, it could be quote-unquote bad evidence for the defense, like a prior arrest record, for example. But if it turns out that it can be used by the defense for the purposes of either impeaching or preventing impeachment of one of their own witnesses, that could be considered favorable to the accused, and it has been, in fact, in the past. Anyway, the second requirement is that the evidence must have been suppressed by the state, either willfully or inadvertently. And the last element is that prejudice must have ensued. In other words, it should have affected the defendant in a very negative way in terms of their trial or preparing for their trial, etc. So basically, if we take everything that I just went through and apply it to this particular case, what becomes very clear is that this was easily a case where a Brady violation occurred. First, we do have evidence here that at the very best for Baldwin could help a theory that Seth Kenney actually sabotaged the Rust set. Now, I don't personally think that this is a perfect silver bullet, for lack of a better term, for Baldwin's case. It's not like this evidence would eliminate the analysis about whether or not he was reckless or criminally negligent on the Rust set, for example. And that, to me, at least, was the most important critical part of this particular case. However, the standard here isn't that it has to be evidence of a perfect defense in order for it to be a required disclosure. At the end of the day, this evidence is potentially helpful to Baldwin's defense. And even if they decided not to use it for that purpose, at the very least, Seth Kenney was a star witness for Hannah Gutierrez-Reed's trial, and it seemed like he was getting set up for the same in Alec Baldwin's trial. And this evidence, the evidence that was withheld here, would have been impeachment evidence against Seth Kenney's credibility. So it definitely was material evidence, regardless of whether Morrissey came to her own independent conclusion that it somehow wasn't relevant. Anyway, next we look at whether the state suppressed the evidence. Personally, I don't know if you can show evidence suppression by the state any clearer than testimony from multiple people who were working on the investigation, where they're admitting that they put the evidence in its own brand new case file and then failed to disclose that separate case number to the defense. Essentially, this is like putting it in a black hole for safekeeping and, again, not telling anyone about it. There's no way for the defense to find out about it. And when they requested all of the evidence from the Rust case, it's like the prosecution and investigation team was like, sure, here's everything in the Rust case file. While at the same time, they knew that this other evidence existed in this other black hole that they had created. And the thing is, Morrissey isn't excused by supposedly not knowing about the separate case number. At first, I don't know that I even believe that she didn't know about it, because how could she not? But second, again, she has an affirmative duty to get into those law enforcement records and know what's going on with the evidence of her case. As the attorney leading this entire case, that is her responsibility. And remember, it counts as evidence suppression, whether it's done willfully or inadvertently by the prosecutor. Negligence, sloppiness, blindness, none of these excuses are acceptable under this analysis. Anyway, the final requirement is that the defendant has to have been prejudiced. And this is really simple too. The defense is seemingly finding out about all of this in the middle of trial. There has already been testimony by multiple witnesses about the rounds found on the Rust set. And this is a topic that the defense included in their opening statements. And remember how I said in the day one recap that opening statements are, in a sense, a series of promises by both sides. Well, if you promised a bunch of stuff to the jury at the beginning and then learned new information in the middle of trial and then had to shift your message at closing arguments, that's something that can look really bad to the jury for your case. So by not having this information, this arguably has impacted their trial strategy one way or another. There are just so many ways that we can look at it and come to that conclusion. And that is prejudice. So in my opinion, here we have all the elements of a Brady violation, easily. But here's what Judge Mary Marlowe Sommers decided.
So dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So, in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teske gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper. State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state. Quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, where all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. State v. Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has inherent power. Per State v. Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
So, obviously, I agree with Judge Marlowe Sommers' decision here. And the thing that's most ironic is that had the prosecution actually disclosed this evidence, I think there still was a really good chance that Baldwin would be convicted. Of course, it's always a big mystery what the jury would have decided when we don't get a conclusion from them. Juries can always be mysterious, and in this case in particular, I really wasn't sure how this thing was going to go. But the main issues in this case, as they were set up from the opening statements, was on this divergence between this idea that firearms are firearms regardless of context, and anyone holding one is subject to their cardinal rules, versus an actor on a movie set should be able to rely on the framework of the rules within production to not need to think about safety for a firearm. That's why they have safety employees. And that grand question that really was very interesting, at least to me personally, it wasn't impacted by this issue of Troy Teske's live rounds. However, I said it before and it bears repeating here. The standard is not whether it would have on its own significantly changed the course of the case. It really doesn't have to be that dramatic to be a Brady violation. And I also want to say this about the issue. I've seen quite a few people lamenting about two things. Number one, a lot of people have called this a technicality. This is not a technicality. This is a constitutional right, and there is tons and tons of Supreme Court case law to support it. It is that important. Constitutional rights are not technicalities. They are what prevent the individual from being completely subsumed by tyranny. The rights enjoyed by Alec Baldwin that were protected on day 3 of this trial are the same rights that every American has. And it's one of the reasons why we are blessed to have the judicial system that we do have. It is not perfect. It certainly has plenty of things that can and should be worked on. But this was an example of that system being held to account so that the wheels of justice turn in the way that they should be turning. Regardless of whether you think that Alec Baldwin is an a-hole or whether you think that Alec Baldwin probably was guilty of involuntary manslaughter, this was the exactly proper result to see this case dismissed for this reason. When Brady violations happen, we have extreme remedies for a reason. And that is because we cannot allow for a single instance of the government to overextend its power when it stands in an already powerful position, when so much is on the line for an individual and specifically for their individual personal freedom. And so this result is justice. And that leads to the second thing that I've seen people lamenting about, is that they say, now there's no justice in this case now that this has been dismissed. And I will say, I understand where people are coming from on this one. When there is a case where someone has died and the defendant is not convicted, it's understandably really hard for the family of the victim or the alleged victim. For those people, there is no closure in that circumstance. But when we talk about justice, keep in mind, justice and convictions are not the same thing. In order for the public to retain their trust in our judicial system, the public has to believe that when a conviction happens, it happens for the right reasons. Otherwise, there is no justice in that conviction and there's no real closure for the family of the victim. And when the judicial process reveals that in pursuit of a conviction, the government has done something very wrong to the defendant's constitutional rights, justice is seeing that defendant walk. But those are my thoughts. What do you think? Was this a proper result? All things considered, do you think that Baldwin would have won or lost if that evidence had actually been turned over to the Baldwin team? What are your thoughts on Morrissey and the law enforcement team that she worked with as a result of all of this? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out. And if you really want to support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by supporting on Patreon. And doing so means that over the long term of this channel, we can continue to devote intensive resources to trials like this one, as well as other interesting legal topics. Links to both are in the description below. Anyway, see you in the next one.